So I want you to understand the Joe Biden White House is saying a radical who wants sex offenders, who wants pedophiles to be able to live next door to daycares. That's who should be a federal judge.
Senator Cruz.
Thank you, Mr. Chairman. I'm glad to welcome our colleague, Senator Feinstein, back to this committee. But I will say what's going to happen next, I think, is going to be quite unfortunate for the American people. Because what we're about to see this committee do is vote on several nominees who are so extreme, who are so unqualified, that they could not have a prayer of getting even a single Republican vote on this committee. And as everyone knows, Senator Graham votes for most of Biden's nominees. It is unusual that Senator Graham does not give a Republican vote to a Biden nominee. But there's a small subset of these nominees that are so beyond the pale that they have no prayer of getting a Republican nominee. And frankly, if my Democrat colleagues valued the responsibility of the Senate's advise and consent, my Democrat colleagues would tell the White House these nominees are unacceptable. This first nominee, Charnel Beckelgren, is so amazingly unqualified, she may well have the title for the least qualified nominee I've seen in 11 years serving on this committee. When Senator Kennedy asked her what Article 5 of the Constitution was, she had no idea. When Senator Kennedy asked her what Article 2 of the Constitution was, she said, I don't know. Mind you, Article 2 is the provision of the Constitution that creates the president and the executive branch of the government. Any first-year law student that didn't know what Article 2 of the Constitution was would flunk con law. This is not some obscure question about some Latin phrase no one should know. This is literally the basic architecture of our Constitution. By the way, Joe Biden has nominated her to be an Article 3 judge. Article 3 is right after Article 2. It creates the federal judiciary. I assume she doesn't know what that is either. I would note that the chairman, in defending her, suggested, well, gosh, there may be some members of our committee that don't know what Article 2 is. I feel confident that's not true, but if there is on either side of the aisle, you should stand up and resign the committee right now. To give you a sense of how unqualified this nominee is, she listed in her judiciary questionnaire her top 10 litigated cases. And I just want you to pause and read this for a second. Her top 10, she did a driver's license revocation. She did a second driver's license revocation. She did an unemployment benefits appeal. She did another unemployment benefits case. She did another unemployment benefit case. And her sixth case was an unemployment benefits case where on the opposing side was a pro se litigant. In other words, this poor fellow didn't have a lawyer. And you know what? The pro se litigant beat her. She lost to a pro se litigant. What's her seventh most consequential case? I'm sorry, there isn't one. There's not an eighth, there's not a ninth, there's not a 10th. She's argued over a couple of driver's licenses. And the Biden White House says you should be a federal judge, an Article 3 judge, not that you have any idea what in the hell that is. In this administration, if you are a left-wing radical, it doesn't matter if you're competent. In Washington state, is there not a single competent lawyer who is competent to be a judge? And by the way, for all the Democrats, since Joe Biden has become president, every one of you has rubber-stamped every single nominee. Is there not a one of you that is willing to say enough is enough? When Donald Trump was president on the Republican side, we confirmed some fantastic judges, but there were several we sent back that we said, no, you missed it on this one. There's not even one Democrat willing to say enough is enough. And by the way, she's not the only one. Another one being considered, a nominee, Cruz. Thankfully not spelled C-R-U-Z, spelled C-R-E-W-S. When asked about Brady versus Maryland, one of the foundational criminal law classes, again, first-year criminal law, You learn about Brady. She said, I'm sorry, I don't know what Brady is. That'll be a problem if she's ever presiding over a criminal case. There are a number of members of this committee who have tried criminal cases. Do you know what Brady is? Of course you do. Because if you're remotely competent, you know what it is, not this judge. Look, sadly, the standard for nominees now seems to be licensed attorneys in Washington. Have you ever handled a criminal case? You ever tried a jury trial? Have you ever stepped foot in federal court? Well, then please contact Senate Democrats, because you too can be a federal judge. I want to end with one more nominee that we're getting ready to ram through on party line votes. That is Judge Marian Gaston, nominated for a seat in San Diego. Judge Gaston, look, we've seen some radicals. We had a nominee earlier that this committee rubber stamped who said he woke up every morning motivated by his hatred for conservatives. Senate Democrats says, sounds like a judge to me. But let's see just how moonbat crazy we're willing to put on the bench. Here's a quote from Judge Gaston. Children are not safer because registered sex offenders are prohibited from residing near schools, parks, daycare centers, and other places where children tend to gather. And in fact, Judge Gaston continued, let's go to the next one. Judge Gaston continued, the conclusions and recommendations are that, difficult as it might be, so at least Judge Gaston recognizes this is pretty wingnut, the conclusion, laws that regulate where sex offenders may not live should be repealed or substantially modified in the interest of public safety. So I want you to understand the Joe Biden White House is saying a radical who wants sex offenders, who wants pedophiles to be able to live next door to daycares. That's who should be a federal judge. Look, some of y'all here represent blue states. Many of y'all represent blue states. I guarantee you in any one of your states. You go to Vermont, ask the people of Vermont, hey, what do you think about having a pedophile live next door to an elementary school, to a kindergarten, to a daycare? They'd look at you and say, are you out of your mind? That's who the Biden White House has given you. Now, I genuinely don't understand why Senate Democrats on this committee don't have enough respect for the constitutional role of the Senate to exercise some check and balance on the White House. I don't think they'll make you hand in your card-carrying Democrat cards to say, gosh darn it, we ought to have a judge who knows what the heck he's doing. John Kennedy has left bloody carcasses in this hearing from Trump nominees who didn't have sufficient experience to do the job. I ask my colleagues, if you vote for these nominees, you're going to have to defend them to your constituents. You're going to have to explain why a lawyer who handled a couple of driver's license revocations and doesn't know what Article 2 of the Constitution is should be a federal judge in charge of your life, your rights, and the law. And you're going to have to explain why you think it's a great idea that sex offenders and pedophiles should live next door to daycare centers. I think that's nuts. And I think most of our constituents do too.
Mr. Chairman.
Senator Lee.
Mr. Chairman, I too have concerns with this nomination. I've spoken more than on a few occasions about various nominees, people nominated to the courts by President Biden. And in some instances, I've raised concerns in particular about their qualifications. We've had some who have either refused to answer, but more commonly proven unable to answer really basic questions about elementary principles of civil procedure, the Sixth Amendment, the rules of evidence, and even the Constitution. It's concerning on a number of levels. Look, it's not as though there were a shortage of lawyers in America. It's not as though there were a shortage of well-qualified lawyers in America, people who have practiced before federal courts routinely through the course of their profession. Nor is it difficult to find lawyers who are well-qualified based on many years of practice before various federal courts, including in many instances the court to which they've been nominated, who are themselves ideologically compatible with this administration. Legal academia in the United States leans a particular direction, and it's not toward conservatism. So it's not hard to find people who are compatible with this administration's approach to statutory construction, to jurisprudence as a whole, who are also well qualified. That's why I find some of this confusing. And of all the nominees who couldn't answer the most basic of constitutional questions, Judge Belkengren may well take the cake. Again, when asked by Senator John Kennedy, she admitted that she wasn't familiar with Article 5 of the Constitution or with Article 2 of the Constitution. If I'm not mistaken, she said something to the effect that, I haven't litigated over those things. Well, most people haven't litigated over them. They're essential to understand nonetheless. They're critical parts of the Constitution. And it's not as though the Constitution contains that many articles. It's stunning that she couldn't even comment on the subject matter of those foundational constitutional provisions. One doesn't have to have litigated on those things to know what they are and to be expected to know what they are. Look, I wouldn't hire a law clerk who couldn't answer those basic questions. And so I certainly can't fathom supporting a federal judicial nominee for a lifetime appointment as a federal judge who can't. Now, let's stop and remember here for a minute what a federal judge is and does. It's not just that it's a lifetime appointment. It's a lifetime appointment for a job that will impact people's lives, livelihoods, freedom, whether they go to prison, whether they win or whether they lose, on a wide variety of topics. Federal judges are required to be generalists in a very real, traditional sense. They're required to have a pretty significant, deep understanding of the federal rules of civil procedure and the federal rules of criminal procedure, the federal rules of evidence, and they need to know their way around the U.S. Code, and certainly they need to be familiar with the basic elements of the U.S. Constitution. Anyone who's ever practiced before any court, especially the federal courts, as I have, has experienced what it's like to appear before a judge who is less qualified than other judges. And to describe it as a painful experience to everyone involved, especially those represented by the lawyer, is a vast, vast understatement. So we're not just being petty here in raising this concern. This will have real-world implications that can be very painful, that can be very devastating. Most people don't want their case handled, tried, adjudicated by an inexperienced judge any more than they would want to get a root canal performed by someone who doesn't know how to practice dentistry. And so this really is concerning. I know this administration can do better, and I expect this administration to do better. There is no shortage of people capable of doing this. There's no shortage of nominees who know what Article 2 and Article 5 of the Constitution are. There's no shortage of nominees, even who share the president's worldview, who haven't tried publicly to shame a 15-year-old victim of sexual abuse. There just isn't. You don't have to do this. Now, as to the suggestion, that I'm sure it's coming because it's come every time we've raised concerns in the past. Suggestion is going to be, well, you don't raise these concerns when a Republican president is in the White House. That's not true. We did. I personally voted against a number of them who weren't qualified, who had issues. I personally, on occasion, would even reach out to the White House and said, what are you doing? This doesn't work. I'd urge each of you to do the same. Just think of the litigants in your respective states and across America who will be negatively impacted by someone who not only doesn't know their way around the courtroom, but doesn't understand the law. We can do better, and I expect the White House to do so.
Anyone else seek recognition? Senator Padilla.
Thank you, Mr. Chair. I wasn't going to speak, but since one of the nominees from California has been specifically pointed out, I feel an obligation to respond to the attacks, frankly. Judge Gaston is an experienced, highly qualified nominee who has already served as a judge in California since 2015. Prior to her service on the bench, she served as a deputy public defender in San Diego. Judge Gaston has presided over more than 500 trials, including hundreds that have dealt with abuse and neglect of children. And during that time, she is dedicated to the protection of abused and neglected children, and members of the legal community, including child advocates, have praised her for her work to protect particularly vulnerable children. She also spent 3 years presiding over San Diego Superior Court's Resilience is Strength and Empowerment Court, also known as the RISE Court, which serves youth survivors of commercial sex trafficking, ensuring their safety and that their educational, psychological, and physical health needs were met. As part of this work, she also instructed state officials, including law enforcement, on how to best serve and protect children in the courtroom. And I lay all this out, Mr. Chairman, because it is patently incorrect to suggest that a position paper that Judge Gaston co-authored 15 years ago argues that sex offender registries do not keep children safe. Now, I understand the paper is being twisted in bad faith to suggest that Judge Gaston was diminishing the importance of sex offender registries and other laws related to sex offenders, but that is not what it said. What the paper actually did was make several public safety arguments, which, by the way, were supported by local prosecutors, as well as parole and probation groups, and grounded in research. Imagine that, grounded in research about how we can best ensure the safety of our children from sexual abuse by keeping sex offenders off the streets. And specifically, the paper that's being referred to argues that children may be less safe due to the unintended consequences of sex offender residency requirements, which push sex offenders into homelessness. Once a sex offender does no longer have a residence, it is impossible to track them and protect our children. I have entered into the record 4 support letters for Judge Gaston, and I will read from just a few of them to help further make the point. First, from a letter from presiding judge of the San Diego Superior Court, Judge Michael Smith, quote, her commitment to public safety, the protection and welfare of children, and the rule of law. He is writing in her support. Second, a letter from retired Superior Court judge and former district attorney, Bonnie Dumanis, who said that while the residency restrictions at issue in Judge Gaston's position paper were well-intentioned, all of us who care deeply about protecting victims of sexual assault came to realize there were harmful, unintended consequences of adding residency restrictions that would not protect from further offending, but would cause those required to register to go homeless and register as transient. And finally, letter from one of her former colleagues in the district attorney's office, Attorney Phyllis Shess, outlines in his letter of support that the position taken by the paper was not radical, and in fact, California law now provides for individualized residence restrictions rather than exclusion zones as the paper recommended. So I get into this level of detail, Mr. Chair, just to reiterate the point that the paper being referenced is a result of nothing other than a common sense position, advice, recommendation to state officials supported by members of law enforcement, child advocates, and judges. The letters also demonstrate just how very well regarded Judge Gaston is in the Southern California legal community and what an asset she will be on the federal bench. Thank you, Mr. Chair.
I'd like to say, in response to the comments made on the Republican side about the other two nominees, the ABA rated Judge Bjelkengren qualified to serve on the district court. As a Washington Superior Court judge, she presided over 130 jury and bench trials. As an assistant attorney general for the Washington Attorney General's office, she tried more than 150 cases. Judge Cruz was rated unanimously well qualified by the American Bar Association. During his 17 years in private practice, he tried 18 cases to verdict, including 15 as sole or chief counsel, 2018 unanimously appointed by the active duty district judges to serve as a magistrate. In his time on the bench, he's already issued more than 1,700 recommendations and orders and has presided over 5 jury trials. These nominees' records as litigators and as judges are the best indicators of their abilities. Our response during the hearing does not negate, one response during the hearing does not negate a lifetime of service. Justice Amy Coney Barrett had trouble with a question. She was asked to name the 5 freedoms in the First Amendment. She could not do that. Yet she was quickly dispatched to the Supreme Court with every Republican voting in favor of her nomination. Senate Republicans clearly did not take that misstep to be an indicator of her abilities. They confirmed her to the highest court in the land. And I might note, when she was up for circuit judge, she was asked to list the prominent cases in her legal background. She was given an opportunity to list 10. She listed 3. Since the 1980s, the ABA has rated a total of 22 judicial nominees not qualified to serve as federal judge since 1980. President Trump accounted for 10 of these nominees, 8 of whom were ultimately confirmed with strong support from Senate Republicans. So I just say that when it comes to nominees' trial experience and answering questions, there is not a consistent record on the other side.
Mr. Chairman.
I'm going to recognize the senator from Texas again, but I ask him to please let us get to a roll call.
So I'll say 2 things briefly. Number one, Mr. Chairman, you've just made a very powerful and effective indictment of the ABA and its role in judicial confirmations. You're right, the ABA has been wildly partisan, so they routinely find Republican nominees to be unqualified, even when they have decades of experience and very significant experience. And I got to say, if the ABA tells you that if you don't know what Article 2 of the Constitution is, and you've only tried 7 cases, mostly driver's license revocation cases, you're qualified to be a federal judge, well, then the ABA ought to get out of the business of rating judges. And I'll just ask my colleagues something. Every one of you, answer this question to yourself seriously. If you were interviewing a chief counsel, all of us have chief counsels on this committee, if you're interviewing a law clerk, and the interviewee, if you asked that interviewee, what's Article 2 of the Constitution, and that person said, damned if I know, would you hire him? You all know the answer is no. None of you would hire someone who didn't know what Article 2 was to be a law clerk on your judiciary staff, and yet you're all prepared to rubber stamp this person as an Article 3 judge. Let me say secondly, very briefly, I understand why the senator from California wants to distance himself from the record of Judge Gaston, and he suggested that her report was, I think the language he used was common sense recommendations. Well, you know, John Adams famously said facts are stubborn things, so I will point out, I have that report right here in my hand. It is called Position Paper on Sex Offender Residence Restrictions. So it's all about where can sex offenders live? Can they live next to schools? Can they live next to kindergartens? Can they live next to daycares? Yes or no? Judge Gaston helped author it, and the verbatim quotes, quote number 1, quote, children are not safer because registered sex offenders are prohibited from residing near schools, parks, daycare centers, and other places where children tend to gather. Quote number 2, the conclusions and recommendations, in other words, what they're saying in this report, are that, difficult as it might be, laws that regulate where sex offenders may not live should be repealed or substantially modified in the interest of public safety. Mr. Chairman, I ask unanimous consent that the entire report be entered into the record so that people can read it and see that it says exactly what I'm quoting from.
Without objection.
And I have to say to my friend from California, if saying sex offenders should be allowed to live next door to daycare centers is common sense, then that's a very different definition of common sense than most people in Texas, and I suspect most people in virtually all of our states.